Good afternoon, everyone. My name is Myra Hippolyte, and I work with the City of Houston Department of Neighborhoods under the direction of Director Takasha Francis. And on behalf of Mayor Sylvester Turner and Director Francis, we want to go ahead and welcome you to the month of service. The month of service is all about giving back free information to the Houston community. This is a collaboration between 8 partners. It's, of course, the City of Houston Department of Neighborhoods, Neighborhood Recovery, Harris County Appraisal District, Houston Bar Association, Harris County Clerk's Office, Harris County Appraisal District, Lone Star Legal Aid, TSU Earl Carl Institute, and the Houston Volunteer Lawyers. It's all about when you're going through a stressor and you're thinking, oh, okay, what do I need to do? What are the steps I need to take? Let's say you lose your job, you get in a car accident. We've gone through hurricanes. We went through Winter Storm Uri. We also are still going through COVID. And a lot of people have lost their jobs. A lot of people have lost their homes, rental issues, your food. Even when you get in through a stressor like a house, going on fire, burning. What are the steps? How do we talk to an attorney? How do we talk to an insurance clerk? What is the process? And that's what we're here all about. We want to make sure that everyone throughout Houston, Harris County, and the state of Texas has the information they need to make the proper decisions they need in whatever stressor they're going through. Today, we're really privileged to have Mr. Greg Rosenberg. He will be speaking about employment discrimination. A lot of people are going through COVID. You've lost your job, you're going through stressors, and he's going to lead and guide us into the different laws and regulations that can assist us, and we can kind of make the best educated decisions in the process. Thank you, Mr. Rosenberg. You're on.
Thank you so much. It's a privilege to be here. Let me just introduce myself to those who don't know me. My name obviously is Greg Rosenberg. I've been, it doesn't sound like it, I'm a Texan. I've been here since 1983. I'm one of the people who got here as fast as I could and never left. I dedicate my professional practice to representing essentially individuals and claims against their employers. I do later on in my career, I've been doing this for 38 years now. I have started representing some companies, but my heart has always been with individuals and representing them in disputes that they have with their employers. If I were to capsulize my practice, I would tell you that I handle anything that involves an employer and an employee, whether it be employment discrimination, like we're going to be speaking about today, overtime, non-competition agreements, virtually anything that doesn't involve a collective bargaining agreement. I don't do union work anymore, although I had in the past. A little bit of background on me. I'm board certified by the Texas Board of Legal Specialization in the area of labor employment law. I've been board certified since 1994. For those of you who are familiar with what the pattern jury charge is, up until, well, I'll just tell you, a pattern jury charge is basically a guide that judges use at the end of the trial to frame questions that go to the jury to help the jury make their decision as to how to reconcile the evidence by asking certain questions. I was privileged in 1997 to be on the editorial committee for the pattern jury charges, and I'm happy to say that the questions we developed in 1997 are still, for the most part, very subtle changes being used today. The last thing I want to add in recognizing my audience, my private practice is something very special to me. I appreciate the opportunity to represent individuals, but I also am privileged to serve as the general counsel on a voluntary basis. The general counsel for the Precinct 1 Constable's office, Constable Alan Rosen's office, I advise employment law issues, unemployment law issues with that agency, and I've been so since Constable Rosen ascended to office in 2008. So I'm here. I was asked to speak to you about. I was given a wide-ranging array of topics to speak about. And I've limited them to a few topics, and I want to just gloss over them to start, and then we'll get right into it. The first thing I'm going to speak about are federal anti-discrimination laws, and I am also going to talk about state counterparts because this is a Texas group. But we're going to talk about both federal and state and how they overlap and what remedies are available to anybody who might be the victim or feel they're a victim of some type of employment discrimination. The other thing I was asked to talk about, I thought this to be exciting. Sometimes when you get asked to speak to groups like this, it really serves as a jump start, if you will, to do a little research and brush up on your own skills and reacquaint yourself with things that we do on a daily basis. So I'm going to talk to you about some recent United States Supreme Court decisions in the area of employment law. And recent, as you can appreciate, the Supreme Court handles a lot of cases, a lot of different types of cases every single term. And the subject matter varies from time to time. They don't always hit every single term on employment law cases, but there are usually 1 or 2, 3 every year. And I'm going to go back a few years and discuss with you some of the ones that I think have been significant and might assist people in developing a new knowledge of law. And then at the end of the presentation today, I'm going to talk to you about certain subtleties. For example, intentional versus unintentional employment discrimination. And then we're going to close with sexual harassment and types of hostile work environment claims. And that could be sexual, it could be racial, it could be all types of different types of harassment. So getting right into it, for lack of a better way of describing it, until 1964, until the Johnson administration, we really did not have any employment discrimination laws that protected racial minorities, gender, national origin, things of that nature. And we developed in 1964 what people might have come to know as Title VII. So Title VII is part of the Civil Rights Act of 1964, and it's often just abbreviated or condensed, referred to as Title VII. So Title VII was the first law to make it illegal for an employer to discriminate against somebody on the basis of race, color, religion, national origin, or gender. And concomitant with that, and actually with all of the statutes, or essentially all of the statutes we'll be talking about this morning, they also have a retaliation aspect. So it's also illegal to retaliate against a person who either complains about discrimination, files a charge of discrimination with the United States Equal Employment Opportunity Commission, or has participated in an employment discrimination investigation or lawsuit. I'm going to go back and talk about this because it's very important. The other part of Title VII is that the law requires employers to reasonably accommodate applicants and employees' sincerely held religious practice. The only exception to that is that if doing so would impose what the law refers to as an undue hardship on the operation of the employer's business. So it's fairly easy to imagine a classic case of employment discrimination. You generally see it in a racial context, in a religious context, in a national origin context, or a gender context. The employer cannot, the protected class. So anytime you get into things like race, gender, color, national origin, or sex, that's referred to as a protected class, an umbrella, if you will. We'll get to age in a little bit. Age also falls under the protective umbrella. So under federal law, that protective characteristic cannot be the determining factor in an employment discrimination. I always think it's easier to describe it as a because type of situation. So was this person discriminated because he is of a racial classification, an ethnic minority, or something like that? It can't be the determining factor. Under the Texas statute, I'll get to the parallel statute in just a second, the differentiation is whether or not it is a motivating factor, and I'll get to those subtleties in just a bit. The most important part, I believe, is we see, and I see it, I've been seeing it in my practice for almost 40 years, people are afraid to get involved. They're afraid to complain. They're afraid to file charges. They're afraid to protect themselves. And what I want to impress upon this audience is that in many instances, the retaliation case is oftentimes stronger than the underlying discrimination case. So what does that mean? Let's say you have somebody who really believes that they've been a victim of racial discrimination. We always see these glass ceiling cases. I'm not getting promoted, but I like my job. I'm not getting promoted. I should be a supervisor. I'm not. I'm really concerned that if I do something, I'm going to risk my entire job with the company. Now, I always tell people that protected activity is just that. It's protected activity. You don't necessarily have to go to the EEOC to file a charge of discrimination. Even if you were to complain to your supervisor or complain to HR, that then becomes protected activity and is protected from retaliation. So even if the underlying discrimination case is not that strong, whether it's not a very strong racial discrimination case, whether it's not a very strong ethnic minority case, whether it's not a strong religious discrimination case, you still engage in protected activity by complaining about it. Letters to HR. I always counsel people, document. I mean, everything in the world now is electronic, so that's easier to do than it was, say 20 years ago. It's almost automatic right now. But once you complain, you engage in protected activity. The other part of protected activity, which is very important, is I call it a bystander type of a claim. Let's say somebody who you work with is clearly a victim or believes they're a victim of some type of employment discrimination. We often hear people say, well, I really don't want to get involved. I really don't want to be a witness for this person. I know what's going on. I see what this person is going through, but I've got, 2 kids in college. I've got one on the way. All of these factors that would radiate against or mitigate somebody's desire to really get involved. The anti-retaliation laws are equally applied to people who participate or serve as a witness or back somebody else up. So that's very important to know. It's not only the person who is the victim of discrimination who can claim, who has a remedy, but as those who support them. And people don't realize that there are very strict and serious laws that protect people from participating in other people's discrimination complaints. I touched on it a little bit just a few minutes ago. Part of Title VII is religious discrimination. You see that in many different aspects. Some of the most common are Sabbath observances. Different people observe Sabbath on different days, and different religions have different prohibitions against working on Sabbath. Sometimes you see cases where people have to dress in certain attire consistent with their religion or religious beliefs. I think the law has crystallized in recent years where the employer can no longer use that as an excuse if it's a sincerely held religious belief. But the mitigating factor there is that it can't impose an undue hardship on the employer. For example, if somebody is in a religious practice that requires them to wear a long beard, for example, and that person is involved in mechanical machinery that might cause a safety hazard to that person or somebody else, that would be an undue hardship type of a thing. If the business requires certain coverage on Saturdays or whatever the Sabbath day that a particular person observes, if that can be accommodated without an undue hardship, the law pretty much requires the company to do that. Sincere religious beliefs, you see that a little bit. You've seen it a little bit lately with COVID, with COVID testing and mandatory testing. I think we're still in such a developing area with this. There are so many cases that are out there and resolved in different formats. My gut is that the resolution of all those cases are going to just revolve around what I call a standard of reasonableness. I think that the people who were opposing testing were originally being terminated. Now the courts have been reversing a lot of those things. I just don't think it's very clearly developed at this point. I want to turn to sexual harassment just for a second as it relates to Title VII and point out a differentiation between federal law and state law. And this is brand new. When I say brand new, we're talking September of 2021. Most of these anti-discrimination laws have certain requirements that the employer have a certain number of people, a certain number of employees. In just about all of the anti-discrimination statutes, the threshold is 15 employees. If a company doesn't employ 15 people, they're not covered under these statutes. So the Texas legislature, under the Texas Labor Code, it's called Chapter 21 of the Texas Labor Code, which basically parallels all of these federal statutes that we're going to be discussing during this presentation today. The Texas Labor Code has a differentiation that the federal statutes have not applied. So we were seeing situations where people were victims of sexual harassment and couldn't do anything about it because the company wasn't big enough. Just wasn't big enough. There, you work in an 8-person office and you're getting sexual harassed, you're out of luck. Until September of 2021 and the Texas legislature, they made 2 very critical changes that are only available as of the time I'm speaking to this audience, only available on the state side. That is, number one, a victim of sexual harassment can claim sexual harassment against a company regardless of the number of people that company employs. So if the company only employs one person, and that's you, and you're getting sexually harassed, you have an independent remedy. It's no longer a 15 employee minimum. So there's an avenue under statute now that was not available months ago. We just hit April of 2022, not even 5 months. The second thing, and perhaps more importantly under state law, is that the individual supervisor can be held personally liable. So why is that an issue? It's an issue because the person who would be liable, who would be adjudicated to be liable of the sexual harassment, can't hide behind what's called a corporate veil. They can't say that this person was employed by the company and not by me, because the liability now imputes to that person individually. And that is a lot of people, for some reason, this has not gotten a lot of publicity. We see a lot of legislative rulings and legislations of all aspects get a lot of publicity. This one, for some reason, didn't when the laws changed in September of 2021. But I want you to know that it's there and it's available, and it's only available under state law. That distinction really doesn't matter, because if you're employed by an employer who does business in the state of Texas, you wouldn't need to resort to federal law anyway. One last thing I want to add, we all know, or if we don't know what the EEOC does, I'll tell you. The EEOC is a federal agency which has two charges. One is to investigate charges of discrimination, and the second is to conciliate or try to settle charges of discrimination. When you file your case under when you file your case under federal law, you must file your charge of discrimination within 300 days of the last discriminatory event. That's roughly 10 months. So you have roughly 10 months to file your charge of discrimination. And then once you file your charge with the EEOC will then issue a right to sue, and you could then file your lawsuit in federal court when the EEOC issues its right to sue. Or if the EEOC doesn't give you a right to sue within 180 days of filing the charge, you can then request one. State law, Texas law, is a little bit different. You have to file your charge of discrimination within 180 days. So it's half the time, it's essentially 6 months. And you must file your lawsuit within 2 years of the last act of discrimination. Now, what's the difference in filing under the Texas statute, which is the Texas Labor Code, or the Texas Commission on Human Rights Act? The difference is in Texas. Texas is what's called a deferral state. So we have the EEOC on one side and the Texas Workforce Commission Civil Rights Division on the other side. They have what's known as a work sharing agreement, whereas if you file a charge of discrimination with one agency, it's as good as filing a charge with the other. So putting that into better terms, perhaps, when you file in Houston, the deferral agency is the EEOC, so that automatically perfects filing with the Texas Workforce Commission Civil Rights Division. Other parts of Texas, it's the opposite. For example, Corpus Christi, for example, you file with the state agency, and that blends in with the federal agency. The critical thing to remember is the difference if you're bringing it under state law it's 180 days. You have to file your charge of discrimination within 180 days of the last discriminatory event. Under federal law, it's 300. So that provides a shell for how you handle these employment discrimination cases. And now what I want to do is talk to you about certain other statutes that kind of fall within this umbrella, but they're independent of each other, but closely related. So the first thing I'm going to talk about, and I see this a lot in my practice, is the Pregnancy Discrimination Act. So the Pregnancy Discrimination Act, sometimes abbreviated as the PDA, is actually an amendment to Title VII, which makes it illegal to discriminate against a woman because of pregnancy, childbirth, or medical condition related to pregnancy or childbirth. It also has a retaliation aspect to it if you oppose the practice, as many of these do. So the question that's always asked to me is, when is somebody protected? They're only protected under the PDA, and it applies parallel under the state statute if the individual is actually pregnant at the time. So the question I'm always asked is, what happens to somebody who feels that they're a victim of discrimination after they have the baby? Well, after they have the baby, under strict interpretation of the law, they're no longer pregnant. So they don't fall under the PDA category of protection. There may be other areas available for you, but such as the Family Medical Leave Act, which is not really part of my presentation today, but it does provide up to 12 weeks of unpaid leave to care for a newborn. There are other factors available, but to qualify under the PDA or the Pregnancy Discrimination Act, you actually have to be pregnant at the time, and more importantly, the employer has to know of it. So if the employer, a lot of times you see situations where you have somebody who's in the beginning stages of pregnancy and goes through things that normally would be associated with pregnancy, morning sickness, things of that nature. And they're late to work, or they're having difficulty at work, or they're not functioning the way they had before they became pregnant. If the employer doesn't know that that person is pregnant, the employer can't be liable for pregnancy discrimination. So the advice I always give is, when the expectant parent, when the expectant mother feels comfortable advising the public, to advise the employer. That way the employer has knowledge, and the employer can't use the "I didn't know about it" type of excuse. And that happens a lot. And we'll get to that a little bit further in the presentation. We'll talk about disability, and we're going to hit that aspect too. The EPA, so the Equal Pay Act. So the Equal Pay Act actually came 1 year before Title VII. It came in 1963, but it didn't include the whole array of employment discrimination protection that Title VII had. But the Equal Pay Act is pretty clear. It makes it illegal to pay different wages to men and women if they perform equal work in the same workplace. And again, it has a retaliatory provision, and that also is handled now through the EEOC. The next one we're going to talk about is very popular in my practice, the Age Discrimination in Employment Act. Now, that came in 1967. So in that 4-year gap, or that 3-year gap, there wasn't anything that protect people from being terminated or discriminated against on the basis of age. Now, under the ADEA, Age Discrimination and Employment Act, and again, there's a a parallel statute under the Texas Labor Code. People are protected if they're in a protected class. So the protected class is 40, the age of 40 and above, you're in a protected age class. For those of you who are 55 and 60 and feel very young, I'm not telling you you're old. That was Congress in 1967. They did that. And the law states that age cannot be a determining factor in an adverse job action. And under the Texas statute, the standard is a little bit different. It's whether or not age was a motivating factor. So a difference in causation in federal court, you would have to show that age was the determining factor in the adverse job action. And in state court under Texas law, whether or not age was a motivating factor. And the point I'm trying to maybe inartfully impress upon you is that the standard's a little bit easier to prove age discrimination in state court than it is in federal court. The next one I want to talk about is a relatively new one. It's 1990. It's the Americans with Disabilities Act. And again, the Texas Labor Code has a parallel statute that prohibits discrimination on not only a disability, but a perceived disability. So if sometimes these are called, quote, regarded as claims. If you're regarded by an employer as having a disability, whether or not you have one, that also, that invokes the coverage. So a qualified person with a disability is somebody who is able to perform his or her job with or without reasonable accommodation. So there's the reasonable word again. We're always governed under what I've always called the standard of reasonableness. And it's whether or not an employer has to act reasonably. Now, you see this when the ADA and after the amendment first started, you saw this surface in a lot of different aspects. A lot of times facilities are not ADA equipped. Companies didn't have equipment, voice activated keyboards, accessible restrooms, a whole bunch of factors that would go into the reasonableness of the accommodation. And I believe that the trend, or at least my experience has been, that the trend has been to liberalize the interpretation of the Americans with Disabilities Act. But the most important thing that I want you to take from this, because we can't cover everything in the time we have allotted, the only way a company, the only way an employer can be held liable for discriminating against an individual who is disabled is if they know about it. So what we often see, or what I've seen in my practice, resurface time and time again, is you have somebody with a health condition. Sometimes it's a cardiac condition, sometimes it's cancer, sometimes it's diabetes. You never know what it is, but some type of a disability, and the employer doesn't know about it. How is an employer supposed to know that somebody suffers from heart disease? How is an employer supposed to know that somebody suffers from something that will inhibit his or her ability to work? So my advice, and I'm resolved on this, my advice is always to make sure that an employer knows about whatever the disability is, because if the employer doesn't know about it, it can't be liable, and there's no remedy available to the employee who claims to be disabled. You know, there is an undue hardship defense to the ADA. If accommodating a disability would impose an undue hardship, that might be installing certain equipment that would be economically unfeasible for an employer to handle, but that's all done on a case-by-case basis. That generally is an overview, because I want to save a bunch of time for some of the remaining things that I was asked to speak about. But that's really an overview of the various laws that prohibit discrimination in employment. One of the things I want to move to, which was the second part of my presentation, is Supreme Court decisions. And I know we're shifting gears here, but the Supreme Court there's no rhyme or reason to what cases a Supreme Court will take in any given term. A lot of times people are concerned from both sides, the employer side or the employee side. People are concerned as to what the ideology of the court's makeup is gonna do regarding certain situations. I could tell you that people were very concerned, those who lean towards the employees side of argument, what the Supreme Court in the makeup that we have now, we're now obviously 6-3 in favor of the conservatives, and what effect that would have on employment discrimination case. And there were some hot buttons that were coming up. The most recent one, and the one I want to talk about first before I get into the rest, it's called the Bostock, B-O-S-T-O-C-K case versus Clayton County, Georgia. That was in a case involving a gay man who was participating in a not intramural, but a recreational type of a softball league that mostly gay people participated in, and he was terminated from his company for actually, it was a public employer, it was a county. People were concerned as to whether or not the true literal meaning of Title VII would be interpreted by a very conservative Supreme Court to include LGBTQ rights. And the justice of the Supreme Court who wrote the opinion on the Bostock case was Justice Gorsuch. He was one of the recent employees when President Trump was in office. And the Bostock case held that Title VII prohibits employment discrimination based on an employee's sexual orientation and or transgendered status. So there's protection that a lot of people thought would never come to fruition. And Justice Gorsuch, if anybody gets a chance, or if anybody has had the opportunity to read the opinion, it is a situation where this justice did everything he possibly could do to make sure that he followed the law, and I applaud him for it. In the opinion, he states that though Title VII does not expressly mention sexual orientation or transgender, remember, it was written in 1964, and it wasn't as out in the open or prevalent in societal purposes as it is today. So though Title VII does not expressly mention sexual orientation or transgender, the court held that homosexuality and transgender status, and I love these words, are inextricably bound up with sex and it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex, which is a protected class under Title VII. That is as pure an interpretation of the law based on sex than you can possibly have, and I was pleased to see that. The court set forth what it regarded as a clear, bright line rule. So in Title VII, Congress outlawed discrimination in the workplace on the basis of race, religion, sex, or national origin. And the court had to decide whether an employer can fire someone simply for being homosexual or transgender. And the answer is clear. An employer who fires an individual, and this is the Supreme Court talking, it's not me. An employer who fires an individual for being homosexual or transgender fires that person for traits or actions it would not have questions in members of different sex. Sex plays a necessary and undisguisable role in the decision, exactly what Title VII forbids. And you know, I need to share personal beliefs. I was asked to make this presentation. My heart has always been with individuals. I was worried about this decision when it was brewing. I was worried about that court, and quite frankly, I was worried about those justices, and they got it right, in my view. When you look, when you do as Justice Gorsuch did, look into the actual guts, if you will, of the statute, and questioned whether the determinant was based on sex, there was no other decision that could be reached. And you know, a lot of people don't like that rule, but it's a rule we're gonna live with as a society, and in my view, be better for it. A couple of other cases that I want to talk about, because I do want to throw this open for questions. There's a case called Vance versus Ball State University. And this talks about a concept called vicarious liability. And I'm going to talk about that in a second. But an employee is a supervisor under the holding of the Vance case. An employee is a supervisor for purposes of a vicarious liability under Title VII only if he or she is empowered by the employer to take tangible employment actions. So you see this vicarious liability issue surface a lot of times in sexual harassment cases. An employer is only liable for sexual harassment if the employer knows of the conduct and fails to take what the court calls prompt, effective, remedial measures to eliminate the harassment. So in a real life scenario, somebody claims they're being victimized by sexual harassment. They report it to their supervisor, and the company is charged with the responsibility of taking prompt, effective, remedial measures to eliminate it. If the company doesn't know about it, they're not liable. But the question then becomes, what happens when it's the supervisor, him or herself, that is victimizing the person? Well, that's what's called vicarious liability. Sometimes you've heard the phrase respondeat superior. It's the same type of thing, whether or not that person is acting as an agent and is actually a part of the company. So the Supreme Court in Vance held that those who would be liable under that respondeat superior or vicarious liability standard is somebody who has the ability to take tangible employment action. So it's an agency relationship type of an issue, right to control, right to bind the company, some type of managerial agency type of relationship. So in essence, what I get out of that case is if the person committing the alleged harassment has binding authority to bind the company, that person would be then liable for the decision. We talked about religious discrimination a few moments ago. There's a case called Eeoc versus Abercrombie and Fitch stores. That case held that an employer may not make an applicant's religious practice, confirmed or otherwise, a factor in employment decisions. So that pretty much goes on what I kind of alluded to a little bit before. What I want you to take out of that is that it just can't be a factor. If somebody comes in wearing religious garb, that can't be taken into consideration by the company in making a decision. The last thing I want to talk about, and we're going to throw it into two more little topics, then we're going to go into questions. From the Supreme Court, there's a concept called constructive discharge. I didn't get into it in the beginning of the presentation because there's a Supreme Court case called Green versus Brennan that talks about it, Brennan. I want to talk first about what constructive discharge is. A constructive discharge is when the circumstances at work become so unbearable that a reasonable person acting under the same or similar circumstances is compelled to resign. You often see it in two distinct aspects: racial discrimination cases, and of course, sexual harassment cases. When the racial discrimination or sexual harassment or any other form of discrimination becomes so unbearable and is not rectified, that person has no other choice but to leave. So that person is considered to be constructively discharged. So constructive discharge is similar to what's known as a constructive eviction in a landlord-tenant type of situation. For example, if you're in an apartment, you complain to the landlord that there's a leak in the roof and it's not fixed, and all of a sudden there's a foot of water on the floor and you can no longer live there anymore. You've been constructively evicted because of the landlord's failure to rectify. In a constructive termination case is exactly the same thing. You're effectively terminated because you have to involuntarily resign. So the reason why I'm bringing up Green versus Brennan, it talks about limitations. You remember earlier in the presentation, I told you there's a 180-day limitations period for state court, a 300-day period for state court. That period begins to run when the employee gives notice of the resignation. So there's a question of when the actual time starts, and that's when it starts. I want to shift gears and just go over two basic things. I'm going to take questions in a bit, I promise you. One of the major factors that differentiates employment discrimination from any other type of discrimination is that you can't discriminate by accident. It has to be intentional. There's no such thing as negligent discrimination. When you accuse a company of discriminating against you, It has to be intentional. There's no way that somebody can discriminate by accident. Why is that important? Because it almost invokes what I like to call it a consciously indifferent standard. If somebody is terminated because they happen to be an ethnic minority or for some other reason, that sometimes is the way it is. But if that was the motivating factor, a motivating factor, that changes the game and makes the action actionable. And that's really all I really wanted to bring up with the topics I was asked to speak about. I'm happy to throw it out to questions. I'm here as long as you need me to be here. I want to make sure I get all the questions answered. So I'm going to turn it back over and tell me how you want to handle the questions.
Right now, there are no questions in the chat. So anyone that has any questions can unmute themselves and ask it personally. Are there any questions that any of you would like to ask? I have a question with COVID. Sure. There were a lot of people that lost their homes, like bartenders. Not lost their homes, but that lost their jobs, bartenders. Right. Could they say that it was an action that they could file on because of COVID? Or if they had COVID?
Yeah, so there were, if the company was no longer functioning, if the service industry, and you see that a lot of bars and restaurants, if the service industry was no longer active, was no longer performing as business, those people would get benefits under the Texas Workforce Commission for unemployment. And I'll tell you, one thing you did see in that situation, and this may be going a little bit off point, a lot of times the benefits that people were receiving for unemployment, and with the stimulus, it was also happening. A lot of these employers were having trouble getting people to return back to work, but there wouldn't be an independent claim against the employer for that.
Okay, and what if someone got COVID and was not able to return back to work? Because a lot of times some people had some extending situations, illnesses, and the employer told them, well, if you don't come back on a certain amount of time, and you're still not COVID free, or you may be COVID free, but have some other situations like you may have heart problems now, or you may have, since you had asthma, now you have lung problems, something like that, because of COVID though.
Yeah, there's a lot to unpackage there. There's no single answer I can provide. I could tell you it's the way we're interpreting those, or what I interpret on behalf of my clients, is it's all resolved under a standard of reasonableness. If you have long-lying COVID issues, there's the ADA type issues. There are a whole lot of different issues available to you. But the question then becomes whether or not you can perform the essential functions of your work with or without reasonable accommodation. If somebody is infirmed because of COVID or whatever, it doesn't have to be COVID, and they can't perform the essential functions, they're not what we call a qualified person with a disability.
Oh, okay. So that answers that one. Thank you so much. I understood that well. Anybody has any other questions? Miss Monica Lugo, you usually have questions, or Miss Nancy? Any of you have any questions that you would like to ask?
No, ma'am, I'm pretty good today. This has all been pretty interesting.
It was. He did really well today. I mean, it's kind of hard to ask questions when you kind of explained it so well, Mr. Rosenberg. Miss Bassett or Miss Nancy, Ms. Patricia Smith, any of you have any questions? These are usually the ones that ask a lot of questions.
Well, that either means I put them to sleep or I got everything addressed. I don't know. I hope I didn't.
You
put them
did a
to
great
sleep.
job.
It
You
was a
actually
privilege
answered
to
it.
speak to everybody.
You actually answered most of the questions, so we want to thank you. And we hope you come back. We want to definitely ask you to come back because you definitely touched all the answers I had and all the questions I had, and you were very detailed. So we'd really love to have you back.
Well, thank you. I enjoyed it. I really did.
Thanks, everyone. And please don't forget to come to our other month of service programs. We're going to be having how to handle inherited property. Don't forget that your generational wealth, protecting your generational wealth and passing on to your heirs is very important. Also, we're going to be having a discussion on April 19th on evictions, property tax values, how to protest your appraisals of your home. And we're also having a will clinic on April 21st. So if you know anyone that's interested in applying for a will or being assessed for a will, have them call me at 832-394-0701. We're also having a first-time home buyer class. Now, let me tell you about this first-time home buyer class. I know a lot of people personally that got their credit cleaned, were able to save enough money and get enough of down payment assistance from the first-time home buyer class to take to buy your first home. It's so important that we all get educated on cleaning our credit, maintaining our credit, and as well as taking the classes that you need to be educated to be a first-time home buyer. Also, we'll have coffee and conversation on April 26th. Now, this is a great one because we're going to have Mr. Victor Gonzalez with the Anti-Gang Office, and he's going to be able to talk to you about the youth, how the city of Houston is able to counsel a lot of our gang members and bring them back to normal living standards, as well as be able to go to school, college, and they're producing these gang members are actually being productive citizens in the United States, which is amazing. So Mr. Victor Gonzalez with the City of Houston Anti-Gang Group will be here for coffee and conversation. Also, we're having maintaining and adding value to your home. A lot of people don't know when you first purchase a home how to maintain it. They don't realize you got to keep an eye on, make sure your warranty, like your 1-year warranty right before it, make sure your air conditioning, everything is working on your home. So we're trying here to make sure that you're educated on maintenance. Here comes the Puerto Rican in me, the maintenance of your home. Get educated, protect your home, take care of it, because this is something you've worked very hard for, and you need to make sure that you get educated on the process of maintaining. And then we're having the last class for April on foreclosures because of COVID. We're having a lot of people that are being foreclosed on and evicted on. I just saw yesterday on the news where some people were, some of the landlords applied for the foreclosure assistance as well as the tenant, and they have not been able to get the money yet. So they're having issues because a lot of the landlords are losing money, and a lot of the tenants are actually going to start getting evicted because of the landlords are not getting the money that was promised to them. So there's a lot of things coming up and a lot of issues and a lot of concerns that are coming in. So guys, if you have anything, any virtual workshops that you're interested in, that you'd like to see, let us know. We're all about giving back free information to the Houston, Harris County, state of Texas community. Guys, know that you're not alone, and have a great day. And I'm going to be quiet because you all know I can talk. I really appreciate seeing you guys. I see a lot of our continuing members, and thank you so much, guys. Have a great day.